YouTube in one case, Commonwealth versus Anitus. The docket number is 19P76. Each side will have 15 minutes to argue. We are familiar with the arguments that you've made in your respective briefs. We're familiar with the factual and procedural history. You needn't recount that for us. And as always, there is no rebuttal. You will see as you begin your argument, there will be a timer in the box where the appeals court seal currently appears. It is the same as the timer in the courtroom, with the exception that we do not have the green, yellow, and red lights. But when your time is expired, a red box will come up to alert you to that fact. If you don't need all of your time, you needn't use it. If you don't reach all of your arguments within the time, of course, you may rest on your brief. And with that, for the defendant on appeal.
Thank you, Your Honor. Good afternoon. Alexandra Deal for Mr. Anitus. This should have been a 1 or 2 day trial about a simple carjacking in Plymouth County. Instead, it turned into a 4-day trial about an alleged crime spree that started with a robbery in neighboring Norfolk County and ended with a high-speed car chase in Rhode Island the following week. The jury heard a detailed description of the Norfolk County robbery from one of the store employees. They saw a video of the robbery. They heard about the ensuing police investigation into the robbery, including evidence collection, and they heard about DNA analysis of that evidence. This testimony came in over 2 days through 6 separate...
I appreciate in your reply brief that you acknowledge that you're not challenging the admissibility per se, but you're essentially challenging the scope, how much came in. So where would you draw the line both as to the robbery and the pursuit to Rhode Island? What was enough in your view?
Well, Your Honor, I think particularly with the robbery, Dwyer and its progeny suggests that what you're really looking for and what's appropriate is a summary of the evidence. And here you've got 2 full days of evidence. So the whole idea behind this doctrine is that you not inundate the jury and distract it from the charged offenses. And the jury wasn't just distracted, it was focused solely on an uncharged offense, and that's the robbery for 2 full days.
But the robbery,
for half of the trial.
Ms. Deal, the robbery was admissible really for 2 reasons: for identity, and also to explain his motive for the carjacking.
That's right.
In order for either of those purposes to be served, the Commonwealth needs to present enough evidence to establish that it, in fact, was Mr. Anitus who committed that other robbery, right?
It needs to establish that, I suppose, at least by a preponderance, so that the jury can make that inference. Because the question is, if the jury believes that he did that, does it then believe that that provided him with a motive for carjacking? And I do think that that can be accomplished in a more summary fashion than a 2-day trial, which is essentially what occurred here.
If for it's a preponderance, but if the evidence is light, then the jury could reject the foundational premise, right?
It could, although with respect to carjacking, the jury doesn't need a motive to find Mr. Anitus guilty of the carjacking. I mean,
no, but they need to figure out whether he was the guy who did it, and if you've got both motive and close proximity, even though these were in different towns and in different counties, they were really quite close. The 2 locations were quite close together, were they not?
They were quite close. But again, I return to the fact that motive is not an element. With respect to the carjacking, the jury need only find that he took the automobile with an improper purpose.
But ID was the defense, right? He called that one neighbor to buttress his claim that it wasn't him. And certainly the evidence at the robbery scene, particularly the DNA, establishes ID. And the Commonwealth needs to prove it was him beyond a reasonable doubt, right?
It certainly does with respect to the carjacking, yes, Your Honor.
And what they've got, you've got his companion, and he hit this market. His companion's picked up. His DNA is there, and moments later he shows up in the parking lot for the carjacking. He says it wasn't him, but the proximity in location and time to this other criminal act that gives him a powerful motivation to get out of there that was the Commonwealth's theory of the case.
Sure, and I'm not denying that the evidence was admissible for that purpose. But again, the question is, in what volume and detail does it come in? And of course, generally, we see these cases in the sexual assault context with respect to other similar acts being used, to argue a certain pattern or something like that on behalf of the defendant. So this is a somewhat different application. But I think that the premise remains that you have to, and the judge, I should mention, I mean, the judge recognized this. He said
Sure.
that he intended.
Let me ask you this: if we didn't have this interesting little tidbit of the town and county lines running between the two locations, a couple of hundred yards apart. If these were brought under these two charges were brought as separate counts under a single indictment, they would be tried together.
Presumably.
And if the defendant moved to sever the two charges because of concern over prejudice, the denial of that motion to sever would not it wouldn't be error to deny that motion, right?
To be honest, I hadn't thought about that before you just brought it up, Your Honor. But in all likelihood, no.
No, I mean, two cases, two charges this closely related in time and place would be routinely tried together, but for the happenstance that they happen to be separated by a county line. And if they were tried together, all of the evidence of the carjacking would have come in, all of the evidence of the robbery would have come in. So the notion that there is an inherently impermissible level of prejudice is a little hard for me to accept, since simply because we've got this county line separation.
I can understand your point, Your Honor, but I still think that with respect to the robbery, the evidence certainly could have been more curtailed, as the judge put it, than it was. And I do think it's important to recognize that he himself did say that on several occasions, and he warned the Commonwealth that it had to pare down the evidence significantly from what it was proffering in the pretrial hearing. And instead of paring it down, exactly what it proffered in the pretrial hearing came in at trial. And it remains the judge's duty to guard against something like that. The judge seemed to have recognized his duty to do that and planned to do that, and then for whatever reason didn't do that. And the limiting instructions that the judge gave did nothing really to remedy that, because he gave one instruction prior to the first of 6 witnesses. The jury went home and then came back. There was no additional instruction. There were several more witnesses the following day. And then he gave, a similar sort of generic instruction in his final charge. So the jury really wasn't told what to do with most of this evidence.
So you're concerned that the evidence, I'm sorry, Judge Maldonado, you had a question.
Yes. So one of the things that you said is that motive was not an element here, as to suggest that maybe that's one of the reasons why it shouldn't have been tried to the extent that it was. But motive is not an element in a lot of cases. And yet, when someone is contesting, as Judge Blake said, the identity, and therefore bringing that, then motive becomes a real part of the case, not for purposes as because it's an element, but it becomes a part of the case because it contradicts the defense. I didn't do it. Here's the reason why. I'm going to show you that I did do it. So motive then becomes very inherently part of this case. So you're not saying that motive was not an important part of this case, given the defense, are you?
No, I think that both of the Commonwealth's theories for admissibility with respect to the robbery evidence are valid theories of admissibility. I think the question
and in this particular case, not just valid, obviously like lots of valid, but in this particular case, given the defense, motive became a critical part of the case.
Sure, I think from the Commonwealth's perspective, that's right. And it wouldn't have been an abuse of discretion to allow the evidence to come in some fashion. It was really the form in which it came in, and the fact that the jury really couldn't have known what to do with it, particularly because it was only instructed once, generally, that you're going to hear some evidence about a robbery, and you can only consider it for this limited purpose. But then, especially, I mean, you're talking about crimes that did happen in close proximity to one another. You've got evidence gathering in that vicinity. It could very easily confuse the jury as to, okay, what crime are they getting evidence for? What crime is the DNA analysis being done, for? I think
you say it could have easily confused the jury, but yet when you have certain of the crimes where he was found not guilty, where can you really show that there's been prejudice by what you say is overkill? Because you're not saying it shouldn't have come in, it's just like too much came in. And that's where the prejudice I'm assuming you're saying really lies, but yet the jury was able to parcel out these charges and be able to find him not guilty in some of them.
Yes, I mean, the jury did find him not guilty, I think, on the ABDW. And, you know, that was a sufficiency of the evidence issue. Obviously, I think there was a question of, you know, whether the person driving the car really intended to hit this woman. I do, you know, I see your point that the jury understood that there were lines in the evidence that it should be drawing and that it drew those in appropriate manners. But I would like to point out that the evidence with respect to the carjacking itself was actually not particularly strong. You've got a witness who says, you know, she thinks it's a black boy is how she described it. She wasn't entirely.
On the question of identity, do I recall correctly that that the police in their investigation recovered his DNA from the steering wheel?
Well, you recall that, yes, that they testified that they compared his DNA to a swab that they allegedly got from the steering wheel, but there's actually no evidence of that. No one could describe where it was on the steering wheel. There are no photographs of that blood. There was blood on the rest of the car.
I'm sorry, but it doesn't matter whether his DNA came from the top part of the steering wheel or the bottom part of the steering wheel?
Well, no, but it matters whether it was actually ever on the steering wheel, and the Commonwealth never produced any evidence other than people's testimony that there was blood on the steering wheel.
That is evidence.
The testimony of the investigators, why, other than that, Mrs. Lincoln, how was the play?
Pardon me?
I said, other than that, Mrs. Lincoln, how was the play? I mean, I don't think you get to say other than the testimonies that they took it from the steering wheel, there was no evidence.
Well, all right, perhaps that wasn't a great way to phrase it, but they did enter photographs of blood elsewhere in the car. There was apparently a large patch of blood on the armrest or something along those lines, which would tend to corroborate the testimony that there was in fact blood there. There were 12 fingerprints lifted from the car. 6 of those were usable. They were not linked to Mr. Anitus. The victim didn't identify Mr. Anitus as her attacker. And then, yes, in the defense case, you had a witness who said that she saw someone else running past who looked like he was running to try to get away from something, dressed similarly to how the carjacker was described, and that he was much lighter skinned than Mr. Anitus. So,
before we run out of time, could I just ask you to briefly comment on your sufficiency argument with respect to the intent to permanently deprive aspect of carjacking? Why is the Commonwealth wrong? Why is indifference not enough?
Well, Your Honor, because I think there are at least a handful of cases that seem to suggest that if one abandons the car in a manner that makes it easily retrievable, as opposed to disposing of something, you know, shipping it off to Ghana or crashing it so that it becomes totally unusable to the original owner, then that does not, in fact, lead to an inference that the person intended to permanently deprive the owner of the car. Because
what's your strongest case?
Well, I think that the strongest case is probably the one that I cited in my opening brief, and if you'll give me just a moment to find the citation, I apologize. It's a little awkward here with the Zoom, the Zoom platform. Well, you know, I don't want to take up the court's time, but I would point the court to, there's, I think, a single case in the Commonwealth that I cited on that aspect. And then there are a couple unpublished cases. And I know this is somewhat of an unsatisfying answer, but it sort of stand for the opposite proposition, which is that if you
cited Salerno from 1970, is that the case? It's on 41 of your brief.
Thank you, Your Honor. I appreciate the.
Or Oliveira from 1999.
I think it's Oliveira that I was thinking of, Your Honor, and I apologize that I don't have the facts of each case in my head at the moment. But I know that I compared this case to a couple of other unpublished opinions where it was sort of obvious that the defendant intended to deprive the person of property because the defendant had disposed of that property in such a manner that it would be impossible for the owner to actually reclaim that property at any point in time. And so the inference there would be much stronger than the inference in a case where the car is simply parked and left there.
So was that the unpublished case was one of those where the shipping off to Ghana came from?
That's right, Your Honor. Yeah.
I think I was on that panel, if I remember correctly.
Oh, okay. And it's hard to get your stuff back from Ghana once it's there, but I think that again shows what inference you're looking for when a person takes another person's property. What
Simply saying that those were cases where there was sufficient evidence and there was more doesn't mean that this is insufficient evidence, right?
Not by itself, no, Your Honor. But I think that as set forth in the brief, the argument is that because he just drove it a short distance, parked it, left it, didn't damage it, that doesn't rise to the level of a sufficient intent to permanently deprive the owner of her property. And I do see that I'm out of time, but if there are any further questions, I'm happy to answer them.
Seeing none, thank you very much.
Thank
We'll
you.
hear from the Commonwealth. You're going to need to unmute yourself.
I apologize. I just noticed that. If it may please the court, Your Honors, Elizabeth Mello for the Commonwealth. Your Honor, the Commonwealth's position.
Can I just jump in for a quick second, ask you to start where counsel left off, which is the question of intent to permanently deprive. You say in your brief that if there are conflicting views of that, it's a jury question. And I think conflicting inferences, I should say, and you cite Lau from 2005. But you also use this language about indifference being enough. What is your strongest case for that proposition?
Well, ironically, Your Honors, the strongest case probably be the same cases that that my sister is citing. If you look at the facts in Oliveira, in that particular case, the owner of the vehicle apparently knew the people who took it. I believe they went to a card game, if my memory serves me correctly, or had dinner or had some kind of interaction beforehand, know each other. He was then attacked with a shovel, beaten, and the car was taken. It was later left, they described as a secluded place, not really sure exactly what that means, but it was driven some distance away from where it was taken, and it was left. And the court in Oliveira does go through an analysis looking at force being used, threats being used, as all factors that one can consider, the jury can consider when they're assessing whether or not the person intended to deprive the owner permanently. So in looking at the court's rationale in Oliveira and drawing parallels to the case that we have here, while there wasn't a weapon involved, this individual was threatened to give up the car. She was forcibly pushed out of the car, manhandled, if you will, in order for the vehicle to be taken. And, while the town that it was taken to is a little over, I believe, 15 miles away, I'm not sure what the mileage distance is for it to be, difficult for one to retrieve their vehicle. It was driven to Quincy. It was left in a parking lot with the door open, the keys in the ignition. And it's the Commonwealth's position that, similar to the factors that the court was looking at in Oliveira, that this was more than a joyride. There was indifference. There was no intention, seemingly, that this 85-year-old woman would know where to find her vehicle, where it was, if it wouldn't be stolen again before she was able to retrieve it. It just sort of seems nonsensical if you're not looking at all of the factors. So that is the Commonwealth's position on that particular matter.
And I want to apologize. I know I said your brief, and I know you didn't write the brief and you're subbing in. So I am aware of that.
Thank you, Your Honor. Are there any other questions in regards to that particular issue?
Why don't you turn to the other arguments regarding the admission of large quantities of evidence of the armed robbery?
Of course, Your Honor. In looking at that particular issue, there's several things to look at in determining whether it was overly prejudicial, some of which has already been touched on this afternoon. One of the first issues is whether or not the jury was so overwhelmed by the evidence that was presented. And it's the Commonwealth's position, as already mentioned, that they were not. And the reason that we believe they were not is because they did acquit him of one of the three charges. They were not so influenced to believe that this is just a bad person doing bad things. Let's find him guilty on everything. They actually, looked at the evidence and considered all of the factors in each of the charges. And then you look to the instructions. Now, from the very beginning of this trial, it was mentioned from the prosecutor herself in her opening, you're going to hear about something that happened in Weymouth. It's for a very limited purpose. He's only on trial for the incidents that happened here. And the site for that, Your Honors, in the opening is volume 2 of the transcript, pages 36 and 37. The prosecutor told the jury he is only on trial here today for what occurred with Mrs. Leary. So right from the very beginning, before they heard any evidence, the jury was tipped off that, hey, you're going to hear some stuff, but it's for a limited purpose. Right before the first witness to testify about the robbery spoke, the judge gave a very clear instruction about what they were going to hear, what the purpose of it was, and how they could use that evidence. So again, very clear about that. The entire instruction is pages 208 to 210 in volume 2 of the transcript. At the end of the trial, at the prosecutor's closing argument, the robbery was mentioned very briefly in passing. There was no focus by the Commonwealth on the facts of the robbery. The focus was really on what happened with Mrs. Leary. This was not a situation where the prosecutor was trying to highlight or emphasize something that was not intended to be emphasized. The closing argument is on volume 4, page 58, where again, it's mentioned in passing and tells in the jury instruction, the final charge, the judge again, very clearly to the jury, what that evidence can be used for, how it is to be considered, its limitations. The jury was also reminded when they were given instructions in regards to the consciousness of guilt evidence that came in, they were again reminded he is only on trial for what happened for the carjacking, the assault and battery, dangerous weapon. Again, reminding the jury multiple times over the course of the trial, beginning and end, that he was only on trial for those 3 charges. That's the only evidence that was to be considered.
To Ms. Heal's point, though, the jury goes home, they come back the next day. It would have been better practice, would it not, to have re-instructed them on the limiting instruction about the evidence they were going to hear that day?
It could have been best practice to perhaps remind them. I know the defendant's argument is that it should be before each witness. And while that might be the most cautious way to go about it, it is really at the discretion of the judge as to when to give those particular instructions. So that's true. While it could be, that really is the judge's discretion. And he did give the instructions. They were clear instructions, and the jury is presumed to have followed them. And it appears they did follow them and correctly apply the instructions, because they did acquit him of one of the 3 charges. To
the chief's hypothetical that he asked your sister, would there be a basis, if these had occurred in the same county, to have severed the robbery from the carjacking for purposes of trial?
I don't believe so. I don't believe so, Your Honor. I believe that they would have been tried together. It is a series of events very closely related in proximity and time. The distance where the evidence was found, the series of events, it's my belief that they would have been tried together had it not crossed the county line.
And one of the central questions examined in the question of whether to join or sever is whether the evidence of one would be admissible in the trial of the other, and vice versa, right?
Correct, Your Honor. And I do believe that they would be, though it would have been for a different purpose had it been all together. That you wouldn't have had the limiting instructions. If there are no other questions from the panel, the Commonwealth would rest on its brief.
Thank you both, and thank you for your cooperation in allowing us to conduct this trial, this hearing in this manner. The case is submitted. We are adjourned.